This is Bentley Tolk for the ERISA Litigation Channel. Today I'm going to talk about a Fourth Circuit case called the Boyd versus Metropolitan Life case, MetLife Insurance Company case. And this is 2011 U.S. App Lexus 6605. It's from March 31st, 2011. In that case, the decedent, when she worked at Delta Airlines, had a group life insurance plan that was administered by MetLife Insurance Company. And she named as the primary beneficiary on that policy her husband, and then as the secondary beneficiary her mother. She later separated from her husband, and there was a court order that said that both the wife and her husband would have no claim to any life insurance proceeds from the other. And in fact, the decedent's ex-husband actually signed the agreement whereby he gave up any rights to any life insurance proceeds. Well, the decedent never changed her beneficiary designation on file with the plan administrator, MetLife. And after the decedent's death, her mother made a claim for the benefits. So did her husband. What happened was that MetLife, relying on the plan documents on file, determined that the ex-husband should receive the benefits. The decedent's mother appealed the benefits denial in writing, but MetLife upheld the denial. The decedent's mother then filed this action in federal district court, and the federal district court granted MetLife's motion to dismiss. What followed was this appeal to the Fourth Circuit. Now, the district court had concluded that MetLife had followed its statutory duty by awarding benefits to the beneficiary designated in the plan documents on file with the plan. Now, the Fourth Circuit affirmed the judgment of the district court, and in doing so, it relied on the U.S. Supreme Court's Kennedy decision, which was from 2009. And in that case, the Supreme Court had interpreted 29 U.S.C. 1104A1D as a wide-ranging endorsement of the plan documents rule. Now, 29 U.S.C. section 1104A1D says that employers must distribute benefits in accordance with the documents and instruments governing the plan. The plan documents rule says that plan administrators look only at the directives of the plan documents in deciding how to distribute benefits. The ex-husband signing the waiver in front of witnesses didn't matter in this case. And it also didn't matter, according to the Fourth Circuit, that the life insurance plan wasn't a pension plan, as in Kennedy. And the Fourth Circuit mentioned that the plan documents rule applies both to welfare plans and to pension plans. What was key in this case was footnote 13 in the Supreme Court's Kennedy case, and the Boyd Court's interpretation of that footnote. That footnote states that the Supreme Court's ruling in Kennedy didn't address a situation in which plan documents provide no means for a beneficiary to renounce an interest in benefits. And that wasn't the case in Kennedy. Footnote 13 didn't help the decedent's mother in this case, because even though she argued that the life insurance plan at issue, unlike the pension plan in Kennedy, didn't contain a formal means for a beneficiary to renounce an interest in benefits, here the husband didn't want to renounce benefits, and in fact he was claiming the benefits. As shown in Kennedy, and also as the Supreme Court had analyzed in Kennedy in the law of spendthrift trusts, an ERISA beneficiary always retains the option to renounce benefits at the moment of distribution. The plan administrator in this case was not authorized to disregard a valid beneficiary designation form, where the beneficiary was not disclaiming his right to benefits. The key point here, in this case, is that plan administrators are not required to examine waivers that are extrinsic to plan documents. Required administrators to do so would cause plan administrators to have to examine the validity of waivers. It would slow down the process on distributing benefits, and also administrators would expose themselves to a multitude of litigation and suits. So the plan documents rule, again, is an important concept, and as the Fourth Circuit has talked about, this gives a little bit more, this really goes into more detail on an interpretation of how it should be viewed under the Supreme Court's Kennedy decision. For the ERISA Litigation Channel, this is Bentley Tolk. Thank you.